Good morning, good morning, good morning. It is bright and early here today, and it's cold. It is cold outside. I actually have the documentation for the final court order or the motion from the United States District Court, Northern District of Illinois, Eastern Division. And I'm going to read it real quick before I get my day going in my direction. I'm going to share my screen, but before I do, please like, share, subscribe, comment. I enjoy engaging back and forth with you guys, but I've been following this court case, and I think it's only fair that I actually share the final results. Okay? Let's do it. Let's do it. This is Jane Doe versus Win Tay Talks. The final order came in on yesterday, and we got the documents. Let's talk about it. Let's talk about it. I don't know if you can see that, but I'm going to read it. I've redacted some of the information that you did not need to see, and it's not my place to put it out there. So let's see if I can make that bigger and make myself smaller. There we go. There we go. It says Jane Doe, DBA, which means doing business as True T, plaintiff, versus Wente Talks. Wente Talks, defendant. Judge Charles P. Kokonaris, and this was in the United States District Court, Northern District of Illinois, Eastern Division. The order is plaintiff's application for leave to proceed in former pauperous, IFP, is denied without prejudice, meaning they can bring it back to the court, with leave to refile an amended application or pay the filing fee by April 16th, 2026. Plaintiff's motion to proceed after pseudonym 5 and 6 are also denied without prejudice. Plaintiff shall file an amended complaint disclosing her true legal name by April the 16th, 2026. Plaintiff is further directed to address the federal subject matter jurisdiction concern identified herein by clarifying her domicile by April 16th, 2026. Failure to do so will result in the dismissal of this case without prejudice. Plaintiff's emergency motion for temporary restraining order and expedited discovery, motion to hold defendant Wente Talks accountable for doxing and harassment, motion to hold defendant Wente Talks accountable for harassment and defamation by co-conspirators, and it has in quotations 10, an emergency motion for protective relief regarding harassment, intimidation, and threats by defendant's associates are denied without prejudice. Let me go to the next page if you don't mind. Give me 1 second because we're on another page. If I could find the document that I'm hiding from myself. Where is it? Okay. Guess we're going to stay where we're at. And I'll just keep reading. Plaintiff may refile these motions once the court has received an amended complaint identifying defendant's legal name, either an amended IFP application or payment of the filing fee, and clarification of plaintiff's domicile for purposes of establishing federal subject matter jurisdiction. See statement. Subject matter jurisdiction, this is the statement by the court. Plaintiff proceeding pro se brings this action against a single named defendant for various state law claims, invoking diversity jurisdiction under 28 USC 1332A. At the outset, the court sua sponte raises a concern regarding subject matter jurisdiction. Federal court requires subject matter jurisdiction in two principal ways. Under 28 U.S.C. 1331, federal question jurisdiction exists when a claim arises under the constitutional laws or treaties of the United States. Under 28 U.S.C. 1332, diversity jurisdiction exists when the parties are citizens of different states and the amount in controversy exceeds $75,000. Plaintiff invokes diversity jurisdiction, alleging that she is a citizen of Illinois and that defendant, Wente Talks, is a citizen of Michigan. For diversity purposes, an individual's citizenship is determined by her domicile. That is, her physical presence in the state combined with the intent to remain there indefinitely, and it cites some case law. Courts consider several factors when determining domicile, including current residence, place of employment, location of property, voter's registration, driver's license registration, and payment of taxes. The court notes that plaintiff alleged she is a citizen of Illinois, yet the mailing address she provided to the clerk's office is in Kentucky. This discrepancy raises a question as to plaintiff's actual domicile and consequently whether complete diversity of citizenship exists. If plaintiff wishes to proceed with this action, she is directed to address the federal subject matter jurisdiction concern identified herein by April 16, 2026. Application to proceed IFP. Before the court is plaintiff's application to proceed IFP, Title 28 U.S.C. 1915 permits a court to authorize a plaintiff to proceed without prepaying fees if she is unable to pay. Proceeding IFP is a privilege, and courts depend on the plaintiff's honesty in assessing her ability to pay, and it cites case law. To identify for IFP status, a plaintiff must fully disclose her financial condition, and she must do so truthfully under penalty of perjury, and it cites more case law. Plaintiffs are eligible to proceed IFP if paying the filing fee will prevent them from purchasing the basic necessities of life, and it cites more case law. The court has reviewed the application and finds it inadequate. Plaintiff states that she has not been employed since approximately 2022, roughly 4 years ago, yet provides no explanation of how she has supported herself and her dependents during that period. Plaintiff reports received $3,000 in gifts and $27,000 in funds from self-employment, business, or profession over the past 12 months, while listing a single dependent and reporting debits of thousands of dollars. With respect to assets and bank account, plaintiff checks no to both. The application does not explain how plaintiff has met basic living expenses, food, housing, and utilities. If she has no employment or savings or bank account, the court cannot accept the implausible claim that plaintiff abstained the basic necessities of life with no visible means of support, and they cite more case law. Plaintiff's IFP application is denied without prejudice with leave to refile by April 16, 2026. Plaintiff must file a new IFP application answering every question completely and accurately. If her report income remains at a near zero, plaintiff must explain in writing on the application itself how she has obtained life's basic necessities, including food, housing, and utilities. Failure to file an amended IFP application by the date or paying the filing fee may result in dismissal of this action without prejudice. Motion to proceed under pseudonym. Plaintiff moves for leave to proceed in this action under the pseudonym Jane Doe. The motion is denied. In the Seventh Circuit, the use of fictitious names is defavored, and courts have an independent duty to determine whether exceptional circumstances justify such a departure from the normal method of proceeding in federal court, and it cites more case law. The Seventh Circuit has limited anonymity to cases in which there is a danger of retaliation and when necessary to protect the privacy of children, rape victims, and other particularly vulnerable parties or witnesses, and it cites more case law. Only exceptional circumstances justify the use of a fictitious name for an adult party, and it cites case law. Such circumstances require a substantial risk of harm, either physical harm or retaliation by third parties, beyond the reaction legitimately attached to the truth of events as determined in the court, and it cites more case law. The burden is on the plaintiff to demonstrate that her privacy interest outweighs the public's and the defendant's interest in open proceedings, and it cites case law. Plaintiff has not met the burden here. First, plaintiff asserts concern about reputational harm is a non-starter. Proceeding anonymously merely to avoid harassment. Proceeding anonymously merely to avoid embarrassment or reputational damage is an insufficient basis for pseudonymous litigation, and it cites case law. Second, plaintiff's generalized references to threats and harassment do not rise to the level of a substantial risk of physical harm or retaliation sufficient to warrant a pseudonym. Generalized risk of harm are insignificant grounds for anonymity, and it cites more case law. Third, the relief plaintiff seeks is in tension with the litigation posture she has chosen. The court has reviewed plaintiff's various filings, including the two exhibits duplicitating online commentary by upset individuals, several of whom appear to be listed as key non-defendant co-conspirators in the complaint, docket number 1. The complaint further expressly reserves the right to amend to name these individuals as defendants once discovery reveals their involvement in the acts alleged herein. Plaintiff cannot have it both ways. She may not shield her own identity from public view while filing a federal lawsuit that identifies other individuals by name, publicly associates them with allegations of serious criminal misconduct, and expressly contemplates naming them as defendants. The asymmetry of that posture weighs heavily against granting anonymity, and it cites more case law. Why should a plaintiff be able to shield himself from public knowledge of his acts when throwing a harsh light on identified defendants? ? If there should be a difference, it ought to run the other way, as plaintiff enjoys an absolute privilege against claims of defamation for what they say in their complaints and beliefs. Plaintiff motion to proceed under pseudonym 5 and 6 are therefore denied. Plaintiff shall have until April 16, 2026 to file an amended complaint that discloses her true legal name in the caption and all subsequent filings, consistent with the Federal Rule of Civil Procedure. Conclusion: for the foregoing reasons, number 1, plaintiff is directed to address the subject matter jurisdiction concern identified herein by clarifying her domicile by April 16th, 2026. Number 2, plaintiff's application to proceed in forma pauperis is denied without prejudice, with leave to refile an amended application by April 16th, 2026. Number 3, plaintiff's motion to proceed under pseudonym 5 and 6 are denied without prejudice. Plaintiff shall refile an amended complaint disclosing her true legal name by April 16th, 2026. Plaintiff's emergency motion for temporary restraining order and expedited discovery motion to hold defendant Wente Talks accountable for doxing and harassment, motion to hold defendant Wente Talks accountable for harassment and defamation by co-conspirators an emergency motion for protective relief regarding harassment, intimidation, and threats by defendant's associates are denied without prejudice. Plaintiff may refile these motions once the court has received an amended complaint identifying the defendant's legal name, either an amended IFP application or payment of the filing fee and clarification of plaintiff's domicile for purposes of establishing federal subject matter jurisdiction. Failure to comply with this order by April the 16th, 2026 may result in dismissal of this action without prejudice. It is so ordered. This day, dated March 17th, 2026, Charles P. Coronas, United States District Judge. I have read to you the court order from the United States District Court of Northern District of Illinois, Eastern Division. We have been following this case pretty closely, and I didn't think it would end this way, not like this, but it looks like there are a lot of things that were not taken care of, and it is what it is. Thought that the judge would give a little bit more of extensive information, but I guess they could only go off of what they had. So we'll keep watching to see if there's anything else that pops up. I don't have any commentary to add to that other than that's what the judge said. I will see you guys in the next one. Y'all have a great day. Get your morning started. Get that coffee in you. Smile at someone. Let them know that they are loved or thought about and that you're okay. That you're okay. If you woke up this morning on this side of the earth, you're okay. And I pray that you have a blessed day. If no one's told you already today that they love you, I love you. And guess what? There ain't a thing you can do about it. Good morning, Symmetry. Good morning, Queen Script. Good morning, All in Unity. Let me add y'all to the screen real quick. I am so glad you guys decided to join me. I was reading and did not look up the whole time. Sorry. Good morning. That's me, AD. Good morning. And y'all, I will see y'all in the next one. Y'all have a great day. Tell somebody that you're thinking about them. If you're driving down the street and someone drops in your mind, give them a call because there's a reason that they dropped in your spirit. Y'all have a wonderful day, as I said. Bye-bye.